Good day, ladies and gentlemen. I'm Ibrahim Mohammed from Kano campus. The topic of today's lecture is company proceedings. The focus will be on types of company proceedings or disputes involving companies. Modes of commencement of company proceedings. Court and tribunals with jurisdiction in company proceedings. Applicable laws or rules in company proceedings. Service of court processes on companies. Various alternative dispute resolution options available to companies. Authentication of company documents. Uses of common seal and official seal. Drafting of heading and prayer clauses of an originating summons and petition for winding up. Drafting of alternative dispute resolution clause. And identifying ethical issues involved in company proceedings. Now, at the end of the lecture, students will be able to identify suitable applications for company proceedings, state alternative dispute resolution options available to companies in lieu of litigation, explain authentication of company documents, uses of common seal and official seal, explain valid service of court processes and documents on companies, draft heading and prayer clauses of an originating summons and petition for winding up, draft the alternative dispute resolution clause, and identify ethical issues involved in company proceeding. Now, let's start with types of company proceedings or dispute involving companies. There are different types of company proceedings. These are company proceedings under the Company and Matters Act, which are usually in form of application to court. Investment dispute, such as dispute arising from the operation and application of the provisions of the Investment and Security Act. And these include capital market dispute, dispute, competition, and fair business practice dispute, which are disputes arising from the operation and application of the provisions of the Federal Competition and Consumer Protection Act. I think labor dispute, such as dispute between or involving companies and trade unions or labor unions. Now, on the types of dispute involving companies under the Company and Matters Act. What court or which court has jurisdiction in the proceedings under the Company and Matters Act? by the provisions of sections 500 or 251 and 567 of the 1999 Constitution and the Company Limited Act, respectively. The Federal High Court is the court that has exclusive jurisdiction for civil matters arising from the operation of the provisions of the Company and Limited Act. The company rules regulate the proceedings in the court. Now, how are actions or how are company proceedings under the Company and Limited Act initiated or commenced? The modes of commencing the proceedings are originating summons, originating motion, petition, and writ of summons. You should note that proceedings under the Company and Limited Act are mainly commenced by originating summons, except where the company rules require the proceedings to be commenced by either petition or originating motion. You should please note the types of application that are required to be made by originating motion and the types of application that are required to be made by a petition. On the issue of writ of summons may be used to commence or initiate company proceedings only in respect of matters of which no provision is made by the company rules. This is because in such where no provision by Rule 19 of the company rules, where no provision is made by the company rules in respect of modes of commencing company proceeding, then the rule of the Federal High Court shall apply. And where the rule of the Federal High Court shall apply, then the action or the proceeding may be commenced by writ of summons, because writ of summons is a common means of initiating civil action in the High Court. Now, let's look at investment dispute. As I said earlier, investment dispute are dispute arising from the operation of the provisions of the Investment and Security Act. Now let's look at the court or tribunal with jurisdiction over investment dispute. The investment dispute, the tribunal with jurisdiction over investment dispute is the Investment and Security Tribunal. There is also the APC, Administrative Proceeding Committee of the Security and Exchange Commission. You should note the function of the APC or Administrative Proceeding Commission, Administrative Proceeding Committee of the Security and Exchange Commission as the gateway to settlement of investment dispute. You should also note the original and appellate jurisdiction as well as functions of the Investment and Security Tribunal. Now, you should also note the applicable laws and rules in company proceeding. And the laws include Company and Allied Matters Act 2004, Company Rules, Investment and Security Act, Security and Exchange Commission Rules, Federal High Court Rules, and others. Now, let's look at service of court processes in company proceedings. You should note the relevant provision regulating service of court processes under the Company and Allied Matters Act. What are the requirements or what constitutes proper service of court processes under company proceedings? Proper service. What constitutes proper service? Serving the principal officers of the company. This includes director, secretary, and any other principal officer of the company. That is for a service to be valid. Also, leaving the court process at the registered office address of the company. However, if it is not an originating process, then leaving it at the company registered office will suffice, will be a good service. But it must be acknowledged by any of the officials of the company. Now, you should know the effect. You should know the effect of failure to comply with the requirement of service, and effect of failure to comply with the requirement of modes of commencing corporate proceedings or company proceedings. The next thing I think is the ADR or authentication of documents, authentication of company documents, use of common seal. You should know that the use of common seal is authorized by the Article of Association of the company. The article of association of the company must authorize how the common seal will be used. You should also note that the company by its seal or under its seal may authorize another person to authenticate documents on behalf of the company, and you should note the requirement of such authorization or authentication. Now, on the issue of alternative dispute resolution options available to companies, there are four modes of there are four options available to companies, and they are negotiation, mediation, conciliation, and arbitration. You should note the advantages of the various options. You should also note the disadvantage of litigation. The aim of the ultimate aim of ADR is, as I pointed out earlier, is to be able to settle the dispute amicably, is to be able to avoid the rigmarole of litigation. Then you should also note the process of ADR or alternative dispute resolution under Section 26 of the Nigerian the NIPC Act, Nigerian Investment Promotion Commission Act. You should also note the process of alternative dispute resolution under the Investment and Security Tribunal ADR Center. You should also note the drafting, the guide to drafting of heading and prayer clauses of processes in company proceedings. A sample of the draft is provided in the slide. You should note that all affidavits and other documents in the proceeding or document supporting the originating process must also be headed or titled in the same manner as, or in the same way as the origination process is headed. You can see the sample in the slide. And for the prayer clause could be based on any of the application required to be made, or the application to be made to the court. Now on ADR, on the drafting ADR clause, a sample is provided in the slide. It is important to note the implication or the effect of failure to provide or failure to insert alternative discussion clause in agreement, in company or in corporate agreements, and the advantages of inserting same in corporate agreements, and where the purpose of inserting Alternative clause is to make provision for ways of settling any dispute that may arise from the agreement amicably. And in drafting the clause, the specific or the particular way agreed to by the parties to settle the dispute amicably must be stated. On the issue of ethical issues, yes, there are many ethical issues involved in company proceedings. Some of the issues have been highlighted in the slide. For further reading on the topic, you can read the recommended textbooks and the slide, of course, and any other material that may assist you. Thank you for listening.